This meeting is being recorded.
Hello, everyone. Welcome to the What Other Lawyers Won't Tell You series. My name is LeTonya Moore. I'm excited about our very first webinar. We are going to be talking about 7 ways to protect your assets and avoid probate. So before we jump right in, I do want to give you guys some housekeeping matters. For those of you that are just joining us, please feel to drop your name, your city and state in the chat box. If you want to be contacted via email later, you can also drop your email address in the chat along with your business website and just a brief introduction about your business as well, if you'd like. We will have time reserved at the end for questions and answers. I would suggest that as questions come up, you want to put those in the chat box because those will be the questions that I will start with answering first, are the questions that are in the chat box. If for some reason you have to leave before we get to your question, you can add your question again along with your email address, and I will send you the answer to your inbox, to your email address, the answer to that question. I'm asking that everyone please mute your audio and hide your video just so it won't pop up in the middle of our presentation tonight. The other thing is that if something comes up, if you'd like to share any type of commentary, you can also feel free to put those things in the chat box as well. If there is something that you just want to share with me, for those of you that are not familiar with Zoom, you have to actually change the drop down to make sure that you are only sharing that information with me. Otherwise, the default is all participants. So just want to make sure that you guys know that, so that you're not sharing information with everyone that you do not want to share with everyone. So gotta first start again with a disclaimer. So any information contained in herein is for informational purposes only. It is not presented to constitute legal advice or to create an attorney-client relationship. So do not act or fail to act based solely on the information contained herein. Before making any decisions, contact a qualified attorney for legal advice for your specific situation. Any redistribution or reproduction of part or all of the contents in any form is strictly prohibited. You may not, except without our express written permission, distribute or commercially exploit this content, nor may you transmit it or store it in any other form of electronic retrieval system. So, who's the presenter, right? Me, LeTonya Moore. So I'm an attorney, I'm a single mom, I'm a 4th generation business owner, and I've been known, I hate to say it, but kind of in the streets, as the brand protector. And I'm really proud of being a 4th generation business owner, but some of the reason that I've created legal education and platforms like this is because even though I'm a 4th generation business owner, no one had any viable business to pass down to anyone else. So we all had that entrepreneurial spirit, but we did not have the education to be able to make it viable so that we could pass that information and pass those businesses down to the next generation to make it, to give them a leg up. And so fortunately, my father is still with us, but I want to be the person in my family that changes that. And so hence the legal education series, because those of you that are here and you're going to be coming to some of the subsequent ones, if you're at an asset protection webinar, you want to know how do you protect these assets so that you can pass them along to, your children or your other heirs. So we're going to jump right in and talk about the 7 ways to protect assets from probate. Now, before I really just jump right into that, I really want you to know that the issue with probate is the fact that, 1, it's public. 2, it's very, very, very costly. 3, why go through all of that? It takes a long time. There is a 6 to 8 month process in most states. It's a 6 to 8 month process minimum. And there can be some estate taxes that are, and inheritance taxes that are connected to it. All of those things are downfalls of probate. To be honest with you, these are things, this is a very difficult time for most people. And you really just don't want everyone in the world or in your local community to really know everything that's going on, right? So in addition to the public, the public information is very, very costly. And I just believe that if you want someone to have something, you need to be in control of that all the way through the process, and also save them money along, as well. Benefits of avoiding probate. 1, again, it's private. 2, nobody else has to know who got what, because we know that's always an issue when it comes down to families and splitting assets and things of that nature. So imagine if there are lots of things involved. I mean, you have people that are arguing over grandmother's silver, for example, and we're going to be talking about more high level things, but just to give you an example of something that could possibly be petty, but could be something that people are fighting over. So if you make sure that you have things set in place, you can avoid all that. And that way things just pass by, by operation of law. So we are going to talk about top 7 ways to protect assets. Now, I don't want to make this seem like there's only 7 ways to protect your assets from probate. These are the top 7 ways to protect your assets from probate, but it's also the 7 ways that we recommend even as part of the Brand Protection Academy. When I work with my clients, for example, these are all the things that I share directly with them on what they need to do to start protecting their assets, their business, their brands, and their babies. Those are the 3 components and the 3 areas that we cover. So I'm going to start with a trust. Probably everyone has heard about a trust, and some of you have probably done some research. Some of you may even have a trust, but is it set up to where it's going to be protecting your assets versus just, let's say, a tax shelter or some type of income shield? People use trust for that as well. So I want to talk about, there's something called a living trust, which is, there are lots of different trusts, but what we're talking about for purposes of probate is a living trust, or it's also called an intra vivos trust. So you'll see it actually listed both ways when you get ready to do your research on what a trust is, what's the living trust, what's the inter vivos trust. A living trust just basically means that this is a trust that you enjoy the benefit of while you're still alive, and then you leave a beneficiary of the trust after you pass away. What happens? That person steps right into your shoes, right? And they become the person who benefits from the assets that are placed in the trust. Any asset can be placed in a trust. Okay, so you can buy stock, you can purchase homes, you can purchase cars, you can retitle, and we're going to talk about that a little bit later. You can retitle things to go into the trust, right? There are lots of different ways that you can set that up, and it really comes down to your unique situation and your unique circumstance. So the great thing actually about having a trust, which is what I like about it, is the fact that you can have it to be irrevocable or revocable or revocable, depending on how you mention that, or how if you're from the South, you're probably going to say irrevocable like me. But anyway, what that means, what irrevocable means, is that once you set that trust in motion, you cannot make any changes to it in terms of like the terms and conditions or how you have things set up, right? Remember, this is a living trust, and the benefit of the living trust is that you have it set up to benefit you right now while you are alive. Okay, so for those of you, if you work a corporate job, for example, and you have a trust account set up, you could actually have your paycheck going into that trust account every month, right? If you own property, for example, and your renters are paying into a bank account, you can easily reroute that to a trust account. Okay. And the reason, there are lots of different reasons for that, which is kind of outside of the purview, but just know that a trust, you can set up a trust to protect all types of assets. Okay. And when you have a trust, anything in that trust or governed by that trust does not have to become a part of your estate. It does not go through probate. It simply passes in the way that you have it set up when you create the trust. That can be irrevocable, meaning that you cannot make changes to the governing document, or it can be revocable, which means that you can make any changes you want whenever you want. Now, there are reasons that I know some of you are probably like, well, why would I ever make it where I couldn't make any changes? Part of that is when people are utilizing this in a tax shelter type of way. Because when you have a revocable trust, there are certain things that can still be done versus a irrevocable trust. But again, that's kind of outside of the purview of what we're going to be talking about today. Again, advantages. There are definitely tax advantages because depending on how much money or what the value of the trust assets are, it may shield your beneficiaries from any type of estate tax or inheritance taxes because it never becomes something that's inherited, right? It's just pretty much a change of ownership. So a trust is a very, very, very good document. Now, I want to address something, and someone had asked me this, but I want to just stick a pin and address that now. Trusts are not just for the very wealthy. Any person can have a trust. It is not just for the wealthy. Lots of people think that, well, I don't have anything to put in the trust. If you have anything, you have something to put in the trust. It just comes down to whether or not this is a good document or a good position that you need to put yourself in.
This meeting is being recorded.
Okay, so number 2, retitling property, right? And a retitle is exactly how it sounds. That means that you take the property from the way that it's titled right now and you actually change the title. So for those of you, I will just use a real estate example, right? Or a car. If you have a car that you have a title to, and let's say that, you have this car and your grandson or someone in the family really, really wants this car, you don't have to leave it to them in the will. You can add them to the title as part owner, which means that if something happens to you, that car does not go into the estate. It goes to the person that's the joint owner of the vehicle. Lots of people don't think about that. They just figure, oh, well, I'm just going to give it to that person. You can do that. It's just, to me, a bad idea. It's clearly a bad idea to do that. And so you don't want to have people fighting over, well, he did this or she did that, and there was some type of undue influence. These are a bunch of things happen. So you want to make sure that you are clearly avoiding those type of issues. The other thing when you're dealing with real estate, for example, is something called a joint tenant with survivorship clauses. And all that says is if you have some real estate, for example, that you want to leave to someone, when you retitle the property, whether that's through a $1 sale, right? Or whether that's through a quick claim deed or however you're going to convey the property. And again, the benefits, there are a bunch of ways to convey the property, but you want to make sure that there is a survivorship clause, because what a survivorship clause does, it says, if I die, this person or these people now become the legal owners of this particular property. Again, it does not go through probate. There is almost an instantaneous ownership change, right? So these are very useful when you are conveying real estate, because then you don't have to worry about who's going to get the 2,000 acres of timberland that you own if you're here in Alabama, right? You don't have to worry about who's going to get the beachfront home that you have that's your second home. So there are lots of reasons why you want to do this and you want to retitle it. You can do that at any point, and you can actually do that without the other party knowing. You can execute a quitclaim deed, for example, and add other people to your property without the other party knowing, as long as you're not removing somebody else off of the property. So before you go out and do something like this, you want to make sure that you have consulted an attorney, right, that can help you with this process. But retitling is really one of the cheapest ways, to be honest with you, to protect assets, because all you're doing is that you're adding people onto deeds, you're adding them onto any type of property that has title. So very important. Again, the benefits is, it doesn't have to go through probate. The other thing too is it cannot be conveyed at all without your knowledge. And what that means is that whoever the person is, for example, if they have an interest in the property, they can't go and get a mortgage on this property without you knowing it. Because again, remember I told you, you don't even have to tell them, but they can't go and do anything without your knowledge. So very important. You still get to, you still get to have control over the property. Now, most of you may be familiar with something called a transfer on death account or transfer on death strategy. A transfer on death account, it allows you to designate a person to receive assets immediately upon your death without going through a probate process. It's very similar to having beneficiaries, right? But this does not apply to life insurance policies. But for any of your other accounts that you have, so if you have CDs, money markets, mutual funds, things of that nature, you can actually, when you should, and oftentimes financial institutions will not tell you this, so you have to make sure that you ask about it, is you want to make sure that it is a transfer on death account or some of the other options, and you want to make sure to ask about it, that we're going to be talking about tonight. And what happens is the name transferee, they don't have any control. They have no authority. They can't do anything with the asset while you, the transferor, is still alive. Now, you can, once you pass away, that person can either maintain the asset, they can keep it as is, or they can liquidate it. It's totally up to them. It just means that now they get what they got it exactly as it was when you left it. Okay, but it must be a designation. Otherwise, it will become a part of your personal property at the time of death, which means it will have to go through probate if there is not a transfer on death beneficiary designated on those accounts. This is very important, because those of you that have any type of mutual funds or anything like that, more than likely they didn't even ask you about it when you opened up the account. They didn't even go over these types of things with you, which is why oftentimes people are stuck in this position. Now, you also have something called payable on death accounts, right? So that, again, name beneficiary on, I'm just using a bank account here as an example. It gives immediate access to them, to the named beneficiary after your death, like the other one. Now, here's the thing. They don't have any access or control over the account while you are alive. It does not go through the probate process, but a payable on death account basically says they get everything and it closed, right? That's the distinction between a transfer on death and a payable on death. The payable on death, let's say you have $10,000 in an account, a bank account, or a $10,000 CD that's payable on death. Well, that person, if they know about it, which they should, they go to the bank, they present an official death certificate, and they're issued a cashier's check in the amount of whatever the value is of that $10,000 CD, right? It's payable. Now, the distinction, again, between payable on death and transfer on death is that in the transfer, ownership is just transferred. They can keep the CD as is, and it can continue to grow and grow and grow, or they can liquidate it. So they do have choices on the transfer on death, versus the payable on death. So it's a slight distinction, but I just wanted to make sure to point that out. Now, joint accounts. I see this with a lot of parents and children. I see this with a lot of married couples where they have joint accounts. And so for those of you that do any type of banking, you know that a joint account is where you have more than one account holder. Now, you only use this if you want that person to have full control and use of the account before and after your death. That means they can take all the funds, right? They can put money in, they can make decisions about the account. They are just as much of an owner of the account while you are alive, just like you are. Again, the benefit is that it does not go through probate and it does not require any type of ownership transfer. So you could dump as much money into that account as you want to, and that person can use it at their leisure before and after your death. So some people are big proponents of joint accounts. Some people are not, but just understand that when you have a joint account, that person has full authorization and full control, just like you do. Now, beneficiary designation forms. These are very important. I am taking for granted that you guys are taking some type of notes, either on your mobile device or on your phone or something, right? Because this is very, very important. If you have not done the things that I'm about to go over, do them like literally tomorrow, okay? One of the things is make sure that you have a designated beneficiary for all of your employment accounts that are connected to your job, right? So like your 401k, if you're a federal employee, you probably have a thrift savings plan. If you have some type of health savings plan, make sure that you have a beneficiary designation form. Because if you don't, right? If you don't, it is literally just going to sit there because they're not going to know who to pay. The other thing too is make sure that you contact your HR so that they know who they need to pay. For example, if you have money that is a part of, let's say, some annual leave or some comp time, something that doesn't quite fall into salary, for example, it may not go into your already existing connected checking account, but it's money that's just sitting there, right? If you've had some type of, performance bonus, or depending on what you have set up, employee stock, all of those things, make sure anything that you have, right? Anything that you have connected with your employer that's money related, make sure, or any type of interest, that includes, again, stock, make sure that there is a beneficiary designated for all of that. For those of you that have remarried, for example, after you did that, make sure that you update those forms if you want to, right? If you want to leave those things to your previous spouse, if you had it that way, that's certainly fine. But anything that needs to be updated, it is imperative that you do that. And this is across the board. So make sure that you update all of those things. Now, here's something that in the last probably 5 years have become big, but you want to make sure that you do those. Make sure that you also have one for all passwords to online platforms, your cell phone, things of that nature, giving someone authorization to obtain that information after your death, right? Why do you want to do that? Sometimes there may be some information that you need that's in your phone. People keep everything in their phone now. They keep everything in the cloud. If no one has access to the password or the online platform, how are they going to get that information? So it's very crucial that you make sure that you do that. You got to do that. Okay? And it could be anybody. Any other accounts that I have not mentioned that you have questions about, you can drop them in the chat, but just know you want to have a beneficiary designated for that. I always tell people to file a form, one, because it looks very formal. It's not just the email saying, this is what I want to do. Almost all companies will have their own form that you just requested through HR. You complete it. You may have to get it notarized or something like that. Take those extra steps to make sure that everything is together and be proactive so that your family or whoever is left behind, they don't have to go through some of these struggles that other people have to go through because they're not prepared. Again, benefits, it avoids probate, it saves your family time, and you really just cut down on a lot of the challenges that other people have. Life estates. Okay, life estates it's a real estate term. It's a common law real estate term. And basically, it is where someone is granted the use and possession of a property interest for the duration of their life. Now, once that person passes away, whatever that property is, let's say it's a house, it goes back to the grantor or it'll go to somebody else, right? What are the benefits? Again, avoiding probate. The grantor typically retains possession and use without giving up control. It's protected from creditors since the only interest is a life estate and not what's called a full conveyable interest, meaning you can't sell the property, you can't do anything with it. Now, I'm going to tell you where these, I've been involved with these. So let's say, example, you have an elderly parent that wants to remain in their home, which most of them do if your parents are like mine, right? They want to remain in their home, but they also want to make sure that they're conveying the property. You want to make sure that their interests are protected, right? And you can do this for yourself too, but you want to make sure that their interests are protected. So what you do, again, you retitle the deed, right? What they will be doing is they will retitle the deed into a life estate deed versus a joint tenant deed. It could be a life estate deed because this is something that they're doing while they're alive. And what they're saying is they want to make sure that they get to live in this property, full use and enjoyment up until they die. When they die, it goes to whoever the next person is. Again, it could be a grantor or it could be, a grandchild or something like that. A lot of people buy homes for their parents and they do this very thing because, again, it's shielded from creditors. Remember, it's shielded from creditors because there is someone with a lifetime interest in it. It's shielded from a lot of other things too, but in terms of today's discussion, it's also another way to avoid probate, and you don't have to worry about losing a home or that person, even if something happens to you, for example, and that person outlives you, you do not have to worry about somebody putting them out of the house or something worse, right? You don't have to worry about that because now they are shielded and protected. So this is really a good opportunity for a parent. This is also a good, a good instrument for parents. It's also a good instrument I've seen for people that have adult disabled children and they may be getting up on in years. So they create this to make sure that child always has a place to live. And then, whatever monetary compensation that they have set up for them and provision set up for them, all of that goes to, make sure that the home is maintained and so on and so forth. Okay, so I know the big question, one of the big questions, without me looking at the chat, is do you still need a will? Right? Because I know this whole time we've been talking about avoiding probate. And for those of you that may not fully know what a will is, basically your last will and testament just tells the state how you want your property and your interest disposed of after you pass away. And that goes through what's called the probate process, right? Do you still need a will? Absolutely. No matter what these things are, you still need a will because there's going to be some things that you forget. You may not think about something or you just may not update something. So there is going to be a catch-all. Some of these things don't apply to personal property. For example, you may have some fur coats, right? You may have some antiques. You may have things that you want to specifically give someone that cannot pass through title. Right? And so because of that, you definitely want to make sure that you have a will, unless you just go ahead and give it to them, but you want to make sure that you have a will to cover those things that were not included. Even if your will is just like whatever was not in, whatever is left goes to, you know, my son, whatever it is, right? Of course, it wouldn't be that simple, but I think you guys get the gist of what I'm saying. Now, you're going to hear, or you probably have heard, a lot of people talk about something called a pour over will. And what a pour over will is, it basically says anything that comes into my estate will pour over into a trust, right? That's a very simple, basic definition. I want you guys to write that down because I want you to also do your own research on that. A pour over will, again, just says whatever comes into my estate will now pour over into a trust. Here's the downside, in my opinion, of a pour over will. It still has to go through probate, which means anything that comes into the estate, even though it's pouring over into a trust, is still going to be listed in the legal notice section of the newspaper, right? It's still a public document that anyone can go and look and see what happened, okay? So again, I'm not saying do a pour over will, not do a pour over will. I just want you guys to know, I mean, you still need a will, but you definitely want to make sure that you understand the implications of not having some of these things that really help you avoid probate. Now, we got to get down to the nitty gritty. Again, a caution, caution, caution. This always happens. Can you do any of these items on your own? So if you take a look at this chair, right, all the pieces are there. It's together, but I don't know about any of you guys, but I don't know that I would sit in that chair. And it's not because it doesn't have a cushion in it, right? It's because, quite frankly, it's put together, but it's not put together right. And it doesn't serve the same function or the function for which it was made for. That is the caution and the danger in doing these things yourself. And quite frankly, these are the people that end up in my office. These are the people that end up being my clients, are the people that said, you know what, I could probably just do this myself. And then somebody passes away and now you have an issue because something was not, it was put together, but it wasn't put together right. And it wasn't put together appropriately. But now for the most part, you're stuck with it. So that's just a cautionary tale for people that are, very intelligent, very industrious, but some things you just don't need to do yourself. And I think that we can all agree with that. So what's my advice? Get it done right. Okay. So I'm going to drop this in the chat for you guys, but I'm going to be doing something called the Avoid Probate Bundle. So these are the things that you'll get, which is what we talked about today. A living trust, right? You're going to get these samples. You'll get a sample living trust documents along with instructions. You'll get sample documents on how to retitle property, some sample life estate deeds so you guys can see. You'll also get a sample pour over will. The code to be able to get the benefit of this is going to be Avoid Probate. And so I am going to be offering that for 50% off. I'll put the link. I'm going to drop the link in there while we're doing the Q&A for those of you to think about it. But this is something that's very important. And when we talk about things like brand protection, right, and we talk about things like generational wealth, rule number one is you want to make sure that you're protecting it, but that is also something viable. You want to make sure that there's something left. But guess what? You want to enjoy it while you're here. You don't build a house for somebody else to live in, right? You build a house so that you can have the comfort and enjoyment as well. Get it done right. Don't forget. Okay, so now it is time for Q&A. Okay, it is time for Q&A. So I'm going to pull up the chat. Okay. Okay, so someone was asking about property and they said, do these principles apply to property that is paid in full before the owner dies? No. No. You can retitle property. Now, of course, there's a lot more to it, but the general answer is no. You can retitle property while you still have a mortgage on it. You just have to disclose that there is a mortgage on it. So it's not that the mortgage doesn't have to be paid or anything like that, because remember, that's still a lien. That just means that the property is conveyed from one person to the other with the lien already attached. Okay? So you got to make sure that you, again, this is why this is not something that you need to try to do. You know, you really don't want to try to do yourself. Let's see. Okay. Well, we have lots of people here. Hi, everybody. You guys are amazing. Okay, so hold on one second. I'm trying to look at the different questions. Okay, so I have another question here that says, if they want to, oh wait, hold on, I think we got somebody else. Okay. So the other question was,